So my name is Tom Schumacher. I am an attorney at Bakke Norman. We're located actually right across the street here from WITC here in Richmond. And then we are also down in Menominee, and we've got a small office in Baldwin as of July 1st. So I want to welcome everybody here tonight. We've got a smaller group than we typically have for this, but I thank you all for coming out this evening, and hopefully you will get some good information that you can use in your work as a municipal official. So the first thing we're going to talk about tonight is a little bit of legislation updates and talk about a couple of cases that have been decided in the recent past. First of all, on the legislative update, first item was a change in the prevailing wage law. Now, the prevailing wage law really primarily deals with, deals with construction contracts, which have to be bid by the municipalities. And most of the time you see it in buildings, streets, roads that municipalities are undertaking. And historically, there's been a requirement that the municipalities, when they bid those contracts, that the contractors have to use the prevailing wage. The prevailing wage would get determined by the Department of Workforce Development, and they would do that by surveys across the state, and they would figure out what the base the wage rate was in a particular area, and then they would add on the typical benefits in that area. And as a practical matter, as I viewed it, they would come up with a wage rate that typically was the cost for union labor in that particular area of the state. And so that would apply to all construction contracts. The change that has been made, and it's not effective yet, it's going to be effective on January 1st, 2017, but the change is that now local governments, towns, villages, cities, will not have to use the prevailing wage rate. So in theory, that will lower your costs for those types of construction projects. If it's a state agency, the state agencies are going to continue to have to use the prevailing wage rate, and the Department of Workforce Development will continue to determine what that wage rate is for state agencies and the state government, but they will no longer decide that for local governments. So that's gone by the board. And so I remember the tensions at sometimes there was issues that came up. Well, if the municipality was doing a road project, for example, and they bid it out and they did it, so you had the prevailing wage rate. And then the issue became, well, with, and this was kind of in the early on when there was a lot of development. We've had periods where there wasn't so much development, and now we're coming back into a period where we have more development. But initially, when there was a fair amount of development going on, particularly residential and industrial, the change was made that particularly in residential developments, that the city wouldn't, or the city or the village would not do the streets. They'd have a developer's agreement, and the developer would do it. And so then the question became, well, whether does the developer have to pay that prevailing wage? So that issue has gone away because no longer is that going to apply to developments that start after a couple months from now, January 1st. So that's one change. Next change has to do with property tax refunds, and that there's various opportunities for a property owner to object to their taxes. And there's specific statutory procedures for them to do so. And on occasion, the taxpayer is successful. And sometimes it's because there was, on occasions there's been a mistake in the tax roll. It's just totally been taxed on either the wrong property or there's a mix-up in the records. But in any event, at some point through the process of the appeal, there's a determination made that the taxpayer would get a refund of their taxes. And the way that they would get that is they would apply to the local municipality to get it. And there's other entities that are contributing to the tax. The school is contributing as part of your real estate taxes. The vocational schools are part of the taxes. The state, in addition to the municipality. And on occasion, in certain circumstances, it would be a situation where the other municipal entities, not the village or not the city or the town, but the school district or the vocational school district would not, the school districts weren't having to refund that money, so it was all coming out of the municipality's pocket. And this law changed it so that municipalities have the opportunity to get that money from those other districts and not have to take the whole 100%. Another item related to adverse possession. Now, adverse possession has to do with when you may or may not have title to a piece of property, but as a real matter, you don't own it. And so what you're doing is possessing the property either because you enclose it by some means, or you maintain the property, or you create improvements on the property, but it's not really your property. And so you're possessing it adversely to another party. And that adverse possession has to be open. You have to be doing it so somebody knows that that's what you're doing. And then it has to be for a period of time. And depending on what the circumstances are, those periods of times vary as to how long you have to do that. Well, the statute was changed so that you cannot adverse against the state or local government. So you cannot do that. But the flip side of it was it also made it a situation where the government cannot adverse possess against property owners as well. And so that kind of went both ways, and that was a change. Typically, this was a private party right, and now that's impacted the government side of it. Next item, in Wisconsin, you know, I've been involved in economic development for a number of years, and only in Wisconsin could a large part of the economic development be related to alcohol. I mean, that's just Wisconsin. That's how it is. And so there are, you know, I think I can't, you know, just through the Regional Business Fund for St. Croix Economic Development, there's been distilleries, there's been wineries, there have been various different alcohol-related operations all being funded in the name of economic development, and they've gone well. And so this is another piece of legislation dealing with alcohol and liquor-related items, and that it provides that, you know, there's a quota system for Class B licenses, and Class B in quotes licenses, so that really means a bar license. And I think how I try to remember that is it's in quotes, it's a bar, and it's beer, and so you're inside, because it's inside the quotes. And so that's kind of how I remember what particular license we're talking about. And what the one provision is that within municipalities, each municipality that has the quota with respect to the Class B based on population, you have the opportunity to buy from another municipality their excess license and put it in your municipality. And there's $10,000 is a non-refundable minimum amount that you would have to do with that. But then you can transfer those licenses and gain some licenses for your municipality. So that's, again, a change. Another option when you're short of a license, but it really isn't going to apply to anybody around here. This is really an example, I think, of where there's some specific project and some specific interest, and they get enough people behind it, or they get the key people behind it, and they pass a piece of legislation. And this has to do with a Premier Economic Development District, which is a creation out of thin cloth that was made by the legislature to address this. And I made a copy of the description of what that is to give you an idea of why it's not likely that that is going to happen here in the northwest part of the state. First of all, the fee for the issuance of this license is $30,000, and it can be, you can issue these additional licenses when the municipality creates one of these Premier Economic Development Districts. And the characteristics of those districts are this, is that it has to be an area not exceeding 40 acres, with an estimated new construction assessed valuation of at least $20 million. So that was, I'm not sure which specific project in the southern part of the state, either in Madison or Milwaukee, which this was designed to address the issue for, but it's an example of how if you have an interest and you have somebody to support that interest in the legislature, you can get something done. So that's an opportunity there for another opportunity for liquor licenses, but not in this part of the state. And then the final kind of legislative update change relates to technology and the internet. And typically when you have to post a notice for towns and villages, you post them in I believe it is 3 different places. And what the opportunity is here is that if the municipality maintains a website, you have the opportunity to post your notices on the website electronically and then post it in one other place. So it's an opportunity to utilize technology and save the clerk some time in running around and posting it in different places. 2 cases that are mentioned here. One of them has to do with right here in New Richmond with the New Richmond News and an issue that they took up in order to get information from accident reports from the New Richmond Police Department. And we'll talk about that in a second. But the case before that is actually a U.S. Supreme Court case, and it had to do with restrictions, municipal restrictions, in this case of towns, on what could be on a sign. And they had different levels of restrictions depending on whether it was a political sign, a directional sign, or in this case a sign that was had to do with at a church. And so what the Supreme Court held that was that when you have restrictions on the content of a sign, that in fact that is you're restricting your First Amendment rights to free speech, and that the particular sign code here violated those free speech guarantees, and so that ordinance was found to be invalid. On the New Richmond News, City New Richmond case, there was a lot of interplay there between Wisconsin's open records law and the law that's the Federal Driver's Privacy Protection Act and what you can get from driver's license records. That's a federal law, and there was a lot of interplay between what the state law was and whether the state law was preempted by the federal law. And that's, there's a lot, I think for lawyers that's an interesting case, and there's a lot of back and forth and a lot of scrutiny and support and criticism of this particular decision. But for purposes of tonight, I think what's important is to discuss or point out what the issue is when somebody comes to the clerk typically and makes a request for a public record. And the first step is that you need to determine whether in fact the document that's being requested is a record, okay? And then the second step is the balancing test on whether the competing interests between making that record available to the public and not making it, what side does that fall down on? And if the balance is that it falls on the side of making the record open, then you can, the record is available. If there's some privacy right and the individual rights that are balanced the other way, then you don't have to release that record. There was another case here in New Richmond that had to do with a personnel records of a teacher and a request from the school district to disclose those personnel records. And typically when they're asking for personnel records, there's a second step in which the municipality has to give a notice to that individual, and that individual has an opportunity to object to those records being released, and then there's a determination made about whether that can happen or not. And so when you get those requests, the first issue is to determine whether or not it is a public record, and then the second thing is the balancing test. Is there some private interest right or right for keeping that record private and not being disclosed on the open record? The policy, the stated policy, and it seems to me that there may be some pushback on that, but the policy historically has been in Wisconsin that records should be open. Government should be transparent, all these records should be open, and they should be available to the public so that they understand what's going on in government and what's happening. And so this particular case had a lot to do with, as I said, the interplay between the federal law and the state law, but primarily the first step that I think is most important for you folks here is that you have to make the determination, is it a record, and the second thing is the balancing test about whether you in fact open that record and disclose it. So with that, that is the just my initial comments with respect